I'd like to welcome you to the final study committee and the culmination of the study committee on the protections from sexual predators, Senate Resolution 371. I'd like to thank the committee members and, more importantly, thank the staff and especially Senate Research, who has worked so diligently on this report and our recommendations. I have to say, I've served on a lot of study committees, and this one has been very complicated. It seems very easy when you look at the precursor to it, but it actually is a little bit more complicated than most study committees are, and that's exactly why Senator Kirk wrote the creation of the study committee, because it is complicated. So just to review everything, we had one study committee and here at the state capitol, and we did have a quorum, and let today's record reflect that we do have a quorum today, and the meeting notice went out, and today is December the 16th, and it's a little bit after 2 o'clock. So with the quorum being present, we have before us the recommendations from the first committee, and I know that we sent out to the committee members input, soliciting input from the committee members, and trying to formulate a recommendation. And that meeting was held on October the 30th of this year. So I know some recommendations did get sent in, and I know I had some input into the recommendations. And Ms. Vaughn, you want to give us a summary of what you think is pretty much a consensus?
Sorry, I'm sitting.
Let you sit right here.
There, I wasn't
I'm going to turn your mic on.
So my name is Beth Vaughn. I'm a senior policy analyst from the Senate Research Office. I think the recommendation that I saw came in through Senator Kirkpatrick, and it was related to shifting the timing for the leveling of the sexual offenders to occur with sentencing, in order, to cure the constitutional defect that the Supreme Court of Georgia saw in the Park case, where someone was being subjected to GPS monitoring after he had completed probation and parole and was no longer serving his sentence, based on a decision that was made by the Sexual Offender Registration Review Board after he was sentenced for his initial crime. So I believe you have that recommendation from the email printed.
So can I ask you a question about it? What I didn't understand. So you go through the adjudication process, and then a judge rules. What is the appeal process if you do that leveling, like we're talking about, and then you disagree with the judge's ruling? Is there an appeal process?
So there is currently, and we address this in the report in the background information. If you look at page 2 to 3 within the draft of the report, we kind of, in drafting this, followed the facts of Mr. Park, because he's, the case that brought us here today. And so he was convicted of child molestation and 9 counts of sexual exploitation of a minor. He was sentenced to 12 years in prison with 8 years to serve. He was evaluated by the Sexual Offender Registration Review Board as his release from prison was coming up, and they determined that Mr. Park was a sexually dangerous predator. And under that subsection of the code, OCGA 42.114, the sexually dangerous predator designation would mean that he would be subjected to lifetime GPS monitoring even after he was done with probation or parole. And that code section, that subsection itself, is on page 2, if anybody wants to see that in its entirety. So he's released from prison. SORB classifies him as a sexually dangerous predator. He then petitioned the SORB, the board, for reevaluation, which is included under that code section, under subsection B, but the board decided to uphold the original classification. From there, the offender has the option to seek judicial review, and he did that, and the Superior Court upheld the board's classification. I believe he also sought a discretionary appeal to the Supreme Court of Georgia, which was denied at that time, so he essentially did everything he could under the code to appeal that designation that he was a sexually dangerous predator, and was denied. He, at a later point, violated the terms of his parole and went back to prison, finished his sentence, and then was released from prison. And he was done at that point. Like, he was not on probation or parole, but because he was a sexually dangerous predator, he was fitted with the GPS ankle monitor. He was later arrested and was indicted for tampering with the ankle monitor, and I believe his attorney, during the testimony from the October 30th meeting, raised some questions as to whether or not that was actually the case. But during that process, so trying to prosecute him for tampering with the ankle monitor, his attorneys raised a variety of constitutional claims, and the Supreme Court of Georgia focused on this question regarding the reasonableness of this ongoing search when he is no longer subject to probation or parole. We had a presentation from the Prosecuting Attorneys Council, and they went through the discussion on October 30th of individuals who might have a diminished expectation of privacy, and that discussion is on page 5 to 7 is their complete testimony. But there are individuals who, like inmates, parolees, probationers, people who are subject to an ongoing criminal sentence, who would have a diminished expectation of privacy, who you could have an ankle monitor on. But once Mr. Park completed his sentence and was no longer on probation or parole, his expectations of privacy were different. And that's what the Supreme Court decided, essentially, was that once he's done with probation or parole, we cannot, as the state, require him to continue to wear and pay for a GPS ankle monitor that tells the state that he might be committing potential criminal offenses, that that's an unreasonable search.
One of the questions I had was, what is a lesser conviction? I mean, they all seem pretty heinous to me, but what would be considered less that you would actually have to wear an ankle monitor? What would be a lesser sentence?
Well, I think the way that it's operating now, whether or not someone has to wear the GPS ankle monitor isn't specifically tied to the offense that they were charged with. If they are subject to categorization by the Sex Offender Registration Review Board, the assessment is how likely is this person to commit a dangerous sexual offense in the future.
Right,
So
right.
it's not, it's
Okay.
more forward-looking.
Okay. That's what
and
I couldn't
please,
understand.
Legislative counsel, anyone correct me if I'm wrong on that, but that was my understanding from the testimony, is that it's a designation that is made by the Sexual Offender Registration Review Board. Is this person a sexually dangerous predator? And if they're...
So they're predisposed to do it again?
Or they have certain factors that would make them more likely to do it. Unfortunately, we're not able to get into the complete metric of how the review board makes their designation, but their executive director, Tracy Alvord, did discuss the static 9-9 that they use as a metric for determining someone's likelihood of committing an offense in the future, as well as the static 2002. So there are parameters that the board uses when making these decisions as to someone's likelihood of committing a future offense.
Okay. All righty, let's see we got some questions. Sue Kirkpatrick.
Yeah, I just want to be sure that I understand my own recommendation. My understanding is that right now, someone's leveling may not match their sentence, because the judge currently doesn't have the leveling information because that takes place after the sentence. And so that means that past offenses wouldn't be considered, but that is considered in leveling by the SORB. Is that accurate?
So I'm trying to not put words into the agency's mouth or into the mouths of others, but just drawing from what I recall Ms. Alvord saying, the Sex Offender Registration Review Board does consider a broader area of factors than what the judge would necessarily have. For example, one of the things that she mentioned, and it's listed in the report, are allegations that were made against this individual but may not have been prosecuted for any number of reasons. They also look at prison behavior, to create that totality of the circumstances by which they decide if they think this person is likely to reoffend. So it is a kind of a broader universe, I think, based on her testimony of what they look at than what is available at the moment of sentencing.
And so my thinking after hearing about this is that if it was part of the sentence, if the leveling was part of the sentence, that would alleviate the problem with the ankle monitoring. Is that correct?
That seems to be what the Supreme Court of Georgia was saying. They don't go as far as to, tell the legislature
Tell us
what to do, but they did strongly hint at examples of what they thought would pass constitutional muster, is the term they throw around. And included in the appendix, you have the complete decision from Park, as well as the concurring opinion. And then you also have the statutes from Michigan that they referenced in the opinion. And in Michigan, it is part of the actual sentence. If you commit certain criminal sexual conduct in Michigan, then you are subject to lifetime electronic monitoring. And that monitoring continues. And so we had a bit of a discussion as well from PAC, I believe, regarding how Michigan operates their monitoring system. And the Supreme Court also pointed to a North Carolina statute that passed constitutional muster as well, and that's under Exhibit C.
See, this one's Michigan. Is this one North Carolina?
Yes, so Exhibit B is both of the Michigan
Okay.
statutes, and then Exhibit C is North Carolina.
Okay.
Oh, it would be, it's just on, it's double-sided, so it's on the back of the appendix.
It's in the very last page.
Yes.
C.
Yes.
Yeah.
And I thought I should also mention the Prosecuting Attorneys Council brought up a Wisconsin statute as well. Like, there are other states that have different approaches for how extended monitoring is applied. And so that's included within the discussion in the report, as well as there's a link online to their whole presentation.
Yes. Mm-hmm.
So am I correct in that the recommendation that I'm making is consistent with the Michigan approach?
It's a little different because the way Michigan structures theirs, it's based on the offense. So if you look at Exhibit B, and it's code section 750.520N, their lifetime monitoring is based on whether someone commits one of those enumerated criminal sexual conduct offenses. So it's based on the offense that that person committed. You know, committed a certain sexual offense, you're going to have lifetime monitoring. The way we had it in Georgia, or have it still, is that the GPS monitoring is tied to the designation by the Sexual Offender Registration Review Board regarding someone's likelihood of reoffending. And so it's I think, a more, the process in Michigan doesn't have that step of the risk classification, like it's based on the offense, so.
It just seems to me like when you have a review by the board, that you get more individualism, that you get more attention to your particular case versus a blanket law that says this is the way it's going to be. You see what I mean?
Mm-hmm.
That every case is unique and different. But then when you give it to a judge can review that uniqueness, right?
I believe that they could, and there is, you know, currently the process that we discussed from the Park case where the offender could challenge the designation
Mhm.
before the Superior Court, like Park did. He
Mhm.
went back to the board, challenged his designation as a sexually dangerous predator, was denied relief there, and then went to the Superior Court and was
Mhm.
denied relief there as well.
Mm-hmm.
So.
Senator?
On the Park case too now, he did his 12 and then ended up doing his 8 after violation. So he completed his full 20 incarcerated before he brought the case, right?
Right, so
Because he was out of state control other than that of the electronic monitoring, right?
Yes, he had completed his sentence and was
Right.
done in terms of his actual criminal
Right.
sentence, both prison or.
And I know that
probation.
was brought up in the Park v. Georgia case, that actually he was out of custodial. The state was no longer a custodian of him because he had completed all aspects of his sentence. I think the advantage of Senator Kirkpatrick's recommendation is that when the judge passes sentence, if he has the leveling information already, like a pre-sentencing review that they do on most cases involving violence, domestic violence, and sexual assault, then he or she makes a educated sentence based on the information that the board has provided, because in the leveling hearings, they are very unique and specific to that individual. And the judge also has past criminal history, whether it's related to sex crimes or any other crime that individual may have been convicted of or charged with anywhere in the United States. So the sentence the judge could give at that time could encompass the fact that the individual would have to wear a monitoring device throughout their natural life, as in the Park case. But that determination was made post-sentence in his case. So
Yes, that's correct.
So Senator Kirkpatrick's recommendation would put it pre-sentence, that the classification would be pre-sentence, and the judge would use that in determining what the sentence would be.
Right, and I think it
Yeah.
might help to look specifically at the language the Supreme Court of Georgia was using. It's on page 21 of the Park
Is this in
opinion.
Park?
Yes, so
Okay.
under Exhibit A, page 21. So statutes authorizing a lifelong GPS search of persons classified as sexually dangerous predators have passed constitutional muster in other jurisdictions, but OCGA 42-114E is distinguishable from these statutory schemes. For example, that subsection does not include the GPS monitoring of sexually dangerous predators as part of the offender's actual sentence. And so I think that's one of the checklist items essentially the Supreme Court was giving to the legislature, is that, you know, if you are wanting to continue with this process going forward, the law would need to be changed. Obviously, it's unconstitutional to do the GPS monitoring after they've completed their sentence. And the board had the data from the October meeting of, I think it was 412 individuals who had currently, as of that meeting, had their monitors removed in response to this decision that it was unconstitutional. But the court does say that if it's part, they imply at least, that if it's part of the offender's actual sentence, that could pass constitutional muster.
But judges already can add drug testing certain boundaries of limitations to sex offenders, therapy, and other things like that at the time of sentencing, to include not only the time they're incarcerated, but time they're on probation and parole. So with Senator K. Patrick's recommendation that the leveling be done pre-sentence, the judge could add the ankle monitoring along with those other sanctions, saying, to use Mr. Park as an example, that the individual would do 12 years incarcerated, 12 years on probation or parole, to be accompanied with substance abuse testing, electronic GPS monitoring, certain classes against, deviant sexual behavior, things of that nature, as long as the judge has all the information at the time of sentencing. Would that be contrary to Park?
No, and what Park is saying is that after you're done
Right.
with probation,
I think Park
parole-
was clearly correct.
So
The decision made by the court was very
It would
clear.
need to be a decision, I think, taking what the court said from that section we just reviewed
Uh-huh.
and applying it on a prospective basis, that if you want to subject someone to lifetime monitoring, so after probation or parole, and the Michigan statute itself says it's available.
It's a particular sentence there, isn't it?
It is,
Yeah.
but it says that this lifetime monitoring is implemented for individuals released from parole, prison, or both parole and prison. So if you're wanting to have this lifetime monitoring, the Supreme Court of Georgia looks to Michigan. The Michigan statute has it as an element of sentencing.
Now, if we did that, if we passed legislation to that, there would still be an opportunity for the offender and their attorney to challenge the classification handed down by the board, whether it was pre-sentence or post-sentence, right? Because they still have the right to appeal, and they could still challenge, I guess, yeah.
It is my understanding that's the case in any
Right.
administrative proceeding. You can appeal it through Superior Court. So if they're not pleased with whatever the court has handed down.
Even the sentence, the original sentence, right?
They can appeal through Superior Court through this board if they have.
Thank you.
Okay. Is there a recommendation? Senator Kirkpatrick, do you want to make that as a recommendation?
Yes. Are you looking for a motion?
Mm-hmm.
Okay. And the legalese will have to be written at a later time, but my recommendation would be that we give judges discretion to put the monitoring in their sentence by having the leveling information available to them at the time of sentencing.
Mm-hmm.
That makes sense.
Is that clear? Okay. Is there a second for that?
Second.
Is there any other discussion? Do either one of you have, do you think you'll be writing legislation on it?
I don't think I will.
I was just wondering
think my
because
ring binder's
I
full.
wanted to be able to talk to Senator Kirk's the reason I'm asking. Because I don't know if he's interested or not since it was his original bill. Do you know have you talked to him?
Well, I was communicating with him this morning, and I think he was interested in a broader
Mhm.
solution that is outside of the
Yeah.
purview of this conversation.
Yeah.
And so I am expecting to get some language on
Okay.
this specific thing
Okay.
sometime soon.
Okay.
And as to whether it's me that does the bill or not, I'm not sure yet.
Okay.
I
Okay.
think I think listening to the testimony at the last meeting especially, I think there are opportunities, and I think that I saw a few things that I think we do need to reevaluate how we monitor sex offenders in Georgia and move the needle back to a more aggressive posture I think when the legislation first came out, it was so blanketing. I think everybody remember we turned every mailbox in rural Georgia into a
Yeah, I remember.
every bus stop
Yeah.
in Georgia. Created a lot of problems, and we
Right.
backed off. And I think all that backing off, I think maybe we have. I've done some ride-alongs since out of session with some of our sex offender community officers, and I do think there's some opportunities for us to kind of tighten things up. So
Mhm. Okay.
protect our children and young people.
Can I double check the wording of the
Mm-hmm.
recommendation?
Sure. You want to read it?
Sure, so just to make it clear what the proposed recommendation is, it would be to give judges discretion to put lifetime GPS ankle monitoring into the sentence by having the leveling information from the Sex Offender Registration Review Board available at the time of sentencing. Okay, thank you. Just wanted to make sure I had that down.
Is there an incongruity of when the board meets and making sure that that information can exchange?
I'm not sure we did not really touch on that, that was not a question that we.
Like
I
scheduling and,
Putting
yeah.
forth to the board
Yeah.
when they were here at the October meeting.
I just wanted to make sure it was practical.
Well, I think what that's going to rest on is a lot of, by the prosecutors, by the district attorneys in
Yeah.
the districts, on those particular cases, working with the board
Right.
in scheduling, because they can set dockets,
Right.
and as long as they're working with the public defenders and
Yeah.
the defense attorneys council, there shouldn't be any problem with holding the sentencing until all information is in, so that
Yeah.
a fair and impartial sentence can be handed down.
Yeah.
I think it's just coordinating within
Yeah.
the
It'll be
judicial
just
circuit.
changing
Yeah.
the way they do business,
That's right.
probably. Okay, there's a motion on the floor and a second. No further discussion. All in favor, say aye. Aye. Let the record reflect that the chairman votes aye also, and it's 3-0. Any other recommendations or any other comments for the study committee? No other comments. I appreciate everyone's attendance and look forward to seeing this move forward. And this concludes the study committee. We'll be publishing the documents and having them ready for the session on January 13th. Thank you very much, and this meeting's adjourned.